Good afternoon, everybody. My name is Adrienne Gould, and I am a program analyst for the Department of the Navy Office of Small Business Programs, led by our distinguished director, Mr. Jimmy Smith. On behalf of the OSBP office, I'd like to welcome you to our series and thank you for joining us today. We started this webinar series as a result of the COVID-19 pandemic as a way to stay connected to our small businesses and get information out to them. We got such rave reviews about our webinars that we've decided to continue holding them, and we've committed to hosting 3 a month on various topics. The Department of Navy recognizes that small businesses are our catalyst to innovation, and we kind of use this platform to highlight that innovation and attract new business partners. You can view previously recorded events at our website under the Outreach and Past Events tab, or you can visit our YouTube channel. I'd like to direct you also to our website, www.secnav.navy.mil/smallbusiness, where you can find a wealth of information to include the OSBP operations plan. You can locate your local small business professional, and you can find out more information on how to do business with the Department of the Navy, to include viewing the Major Command's long-range acquisition forecast plans. I'd also like to stay current on OSBP upcoming events. You can register for our mailing list at our homepage on our website. And to stay up to date about upcoming industry days, various commands, outreach events, and in general what's going on across the Department of the Navy, you can go to our social media venues. We have facebook.com/Navy OSBP all caps, twitter.com/Dawn_OSBP all caps, and then you can go to LinkedIn and just search Dawn OSBP all caps. Some of the webinars we have coming up on the 15th of April, we have the Office of Secretary of Defense's Foreign Investment Office is going to do a webinar on foreign investment in our supply tiers. On April 22nd, we have a PTAC coming to speak to us on DoD matchmaking events. And on April 29th, we have the Deputy Assistant Secretary of the Navy's Office for Procurement coming to talk about NASA. Today's topic is small business data rights and intellectual property. And with us today, we have 2 great speakers. We have Mr. Barry Edelberg, an Associate Counsel at the Office of Naval Research. And we have Mr. John Karasek, a Supervisory Intellectual Property Counsel at the Office of Naval Research. Before we get started with them, I just want to let you know that we are recording the entire event. So the presentations and the event will be posted by our Public Affairs Officer probably end of next week on our website. But if you do need the slides ahead of time, you can always email osbp.pao, all caps, at navy.mil. We can get them out to you. I encourage you to use the Q&A feature to ask any questions. We'll take questions after Mr. Edelberg's presentation, and then we'll take questions after Mr. Karasek's presentation. So don't worry, they're all going to be recorded and you'll see them. So with that, I'm going to turn it over to Mr. Edelberg to talk to us about small business data rights. Over to you, Barry.
Okay, can you bring up the slides here, I hope? Excellent. Okay, so my talk is going to be surprise about SBIR and SIDR data rights. I'm just going to refer to SBIR data rights because I just don't want to keep saying SBIR and SIDR together. So we can move on to the next slide. And just to say the views here are my own. Usually the standard disclaimer here. They don't necessarily reflect the position or policy of the Department of the Navy. So let's move on to the next slide. Now, the 3 basic documents that govern SBIR data rights, you've got the statutory basis, which is 15 U.S.C. 638. You've got the SBIR policy directive from the Small Business Administration, and the most recent one of that is May 2nd, 2019. And then you've got the DFARS SBIR data rights clause, and that was there was a deviation in March of 2020 that was in response to the Small Business Administration's policy changes made in their May 2019 directive. So we can move on to the next slide, I hope. So a SBIR award is any award that's a phase 1, phase 2, or phase 3 award. And the first 2 phases are ones that are addressed in this slide. The first phase is for basically just feasibility, theoretical experimental research, really to see whether there is anything to this SBIR idea, to this initial idea. And then the second, if there seems to be something there, we continue the funding a little bit more and you get a SBIR phase 2. And then, and we move on to the next slide, you get into the more interesting area, which is phase 3. Because phase 3 work, although it's work that derives from, extends, or completes something done under a previous SBIR agreement, is funded by sources other than the funds used for SBIR and SITR programs. And the phase 3 awards can be made years after the original phase 1 and 2 work. There doesn't even need to be actually phase 2 work. You can go directly from phase 1 into phase 3. There can be any number of phase 3 awards. There's no dollar limit on the value of phase 3 awards. And one interesting thing is that the phase 3 work can actually be a subcontract under a different, for example, it can be a subcontract to something that a prime contractor who is not a phase 3 awardee. It can get very interesting in that way. And there's no time limit that can elapse between the different phases of SBIR. So we can move on to the next slide. And SITR data is quite simply any data that's generated in the performance of a SBIR award. It doesn't really matter which phase. It's as long as it's phase 1, phase 2, or phase 3. It's a it's SBIR data, and generated means first created, by the way. And one thing that's interesting is that even if this is a government concept that the SBIR or SITR contractor is working on, then it's still SBIR data because the SBIR contractor first created that data in the performance of a SBIR award. So we can move on to the next slide. And the SBIR data protection period is the protection period in which the government gets these SBIR, only gets the SBIR data rights. They're obligated to protect the SBIR data against unauthorized use and disclosure. And currently there are 2 regimes in play. We can move on to the next slide. It's always best to consult, by the way, your counsel to see which regime is in play for that data. The current regime applies to contracts that were awarded on or after May 2nd of 2019. And it's very simple and straightforward. 20 years from the date of the award of the instrument under which the data was generated. That's not extendable. If you deliver the data under a subsequent SBIR award, there's no extension of the SBIR protection period. After the protection period expires, the government gets government purpose rights. Next slide, please. Now, things get a little bit more complicated for data that's generated under awards made before May 2nd of 2019, because there the award is 5 years after completion of the project, but a SBIR project can include several SBIR contracts, for example, phase 2 and phase 3 efforts. So if you have SBIR work done under if you have SBIR contract and you have SBIR data, then that work is continued under another contract that goes back to the same project. There's an extension of the another 5-year extension of the SBIR data rights. And even if the data rights have expired between the 2 contracts, as long as that data wasn't made available without restrictions in the interim, then the cyber data rights are revived. We call that zombie data rights. Because there's no limit though on the number of phase 3 awards or the time that can elapse between the phases of the awards, and small business limitations don't apply to the cyber phase 3 efforts. Basically, these types of cyber data rights can go on forever as long as there's more and more projects before this data is made available without restrictions. But when these cyber data rights, again under the pre-May 2019 contracts expire, the government gets unlimited data rights as opposed to government purpose rights under the newer regime. Next slide, please. So what can we do with cyber data? Well, basically, for technical data that's limited rights, and for computer software, the cyber data is going to be treated as the government gets restricted rights. So let's move on to the next slide here. Now, there are some exceptions, just as in the case of data generated or data relating to products made under other than cyber awards. There are some exceptions where the government gets unlimited rights. For example, we get unlimited rights in form, fit, and function data. We get unlimited rights in data needed for operation, maintenance, installation, and training. That's omit data, and that's excluding detailed manufacturing or process data. And those are the major exceptions. These other exceptions, corrections, government furnished data, information that's otherwise available to the public, for example, information which has gone into the public domain, for example, published patent applications. Even though the government or nobody can necessarily practice that technology if it's claimed without violating a patent, the technology can still be distributed without restriction, and if it doesn't infringe the claims in the patent, it can be used in that way by the public, and the government can use it as well. And then there's the data where the government has, for example, by an agreement, acquired unlimited rights. So we can move down to the next slide. Next slide, please. Now, cyber data rights, like all other data rights, there needs to be assertions and there need to be markings on the data with the appropriate legend, which for cyber data is the cyber data legend specified in the DFARS clause. One difference though with cyber data is if you're dealing with data that was generated or developed under this particular award, if it's going to be generated under this particular award that you're talking about, you do not need to make the assertions in that contract. It's assumed that all of the data that you're going to be generating under the contract, except for the exceptions that I just mentioned, will be cyber data. So you only need to make sure that you put the markings on that data, the appropriate legends on the data. In subsequent awards, though, you will need to mark that data, even if it's a subsequent cyber award. Next slide, please. Now, the government can't negotiate cyber data rights before award, but the cyber data rights owner, if they want, can waive those rights without negotiation or pressure from the government. Now, after the award, there can be negotiations to transfer data to an awarding agency or third party. That would, my guess, be a contractor, prime contractor, but there can't be any pressure or coercion in that case either. The important thing to keep in mind, both post and pre-award, is there can't be any pressure or coercion. Next slide, please. Now, the new Cyber Policy Directive that came out in 2019 mentions reverse engineering, and they express serious concerns about that. They don't specifically prohibit it, but they do say it's a violation of the purpose and intent of the Small Business Act to release or use a prototype during that protection period that you have in a way that harms the ability to take advantage of the opportunities presented by having CBER or CIDR data. And the SBA is, I assume, in the near future going to come out with some more specific language and specific treatment for CBER prototypes in the future. They have not done so yet, though. Next slide, please. And there are some urban legends that have been associated with CBER data. These are just a few of them. And one of them that I hear from time to time is, well, this can't be a CBER award because it wasn't funded with CBER funds. Well, as you may recall from what I said earlier, CBER Phase 3 specifically is not funded with CBER funds, yet it gets the same data rights treatment as Phase 1 and Phase 2, and it is indeed a CBER award, and it must be treated as that. Another one I hear, I have heard, is that, gee, you only get one Phase 3 award. I don't know if that was ever true, but it certainly is not the case now. There can be any number of CBER Phase 3 awards. And the other one can occasionally hear is that, well, gee, I can force the CBER awardee to price CBER data rights. We can't do that because it's essentially telling the contractor that they have to state a price at which they will depart with their CBER data rights. We can't get them to agree to that in any binding fashion at all. And since that would be essentially a negotiation before award, and it might even be in some cases a coercion for them to give up their data rights. So that is prohibited. Next slide, please. So basically, in conclusion, CBER data rights can be nuanced, and in particular, there can be a question sometimes of whether an award is a Phase 3 award. The most important thing to keep in mind for our contracting officers and program officers is that whenever we're dealing with a situation where the contract isn't, or the data isn't clearly something other than CBER data, and in fact, actually, whenever possible, they should attempt to consult with counsel, and they should never attempt to resolve CBER data rights issues, or for that matter, data rights issues without the advice of counsel. So I think that takes care of my presentation.
Barry, I see you have one question in the question box.
Okay.
And that is, could a company that has data rights under the prior May 2019 rules convert to the new data rights structure?
That, because we can negotiate after award, there would have to be a negotiation of that. And we can do that if there's no pressure, if we're not pressuring anybody. And this is, since we're talking about an award made earlier, we may be able to do that. My concern is that actually negotiation pre-award if there's another contract coming up. So if we're negotiating a contract and somebody wants us to negotiate the rights, that might be a concern. Now, if the contractor wants to come in, or the offeror, and I guess if it's not a contract there, wants to come in and say, I would like to give you this with the data rights regime, and that's acceptable to us, we may be able to do that because that's not a negotiation. because what's prohibited before the contract is negotiation. If we start talking about data rights and what we want and what the contractor wants, and there's give and take, other than making sure the language is correct, that's negotiation. We couldn't do that.
Hey, Barry, one of the other questions that comes up fairly routinely, especially when I'm working with the SBIR program, is there a difference between SBIR data rights and general small business data rights that are not under the SBIR program?
SBIR data rights that aren't, SBIR data rights are basically just under the SBIR funding program. When you're a small business and you're working outside of the SBIR arena, the data that you generate under that contract will be just standard data rights if it's not a SBIR award. Now, if you are talking about bringing in data that was previously generated under a SBIR program, then that data would be entitled to SBIR data rights. You also have to wonder if perchance you're bringing in that data, is this really a SBIR award? Is that later contractor SBIR award? That's where, again, phase 3 gets a bit confusing and difficult to determine, is this really a SBIR phase 3 award? Is this just a standard contract, or because I'm bringing in this work, is that really continuing my effort?
Okay. All right. I know we have that question a lot, so that kind of clarifies that a little bit.
So it can be.
Exactly. Consult with your attorney.
Yep.
Okay, so now we're going to go ahead and turn it over to John on intellectual property. So John, over to you.
Thank you. And looks like Destiny's queuing up my slides. You know, I'll be discussing the rights and inventions made under the Bayh-Dole Act. Like Barry mentioned earlier, these are my personal views only and do not necessarily reflect the position of the Department of the Navy. And this should not be taken as legal advice. Consult your own attorney for legal advice, unless you happen to be working for the Department of the Navy, in which case I would be your attorney and you can talk to me. Next slide. So Bayh-Dole addresses only rights and inventions. It doesn't address other things, other forms of intellectual property. And inventions are those things that may be patentable or otherwise protectable under Title 35. And that means that they're a new and useful process, they're a machine, they're a manufacturer, they're a composition of matter, improvements on any of those things. The type of things that we think of when we think of inventions are those sorts of things. They shouldn't be confused with copyrights, which protect original works of authorship, or trademarks, which protect the identifiers, logos and slogans and brand names to protect the identification of the source of goods or services. People tend to use these terms a little bit interchangeably, so it can be helpful to specify that. Specifically, Bayh-Dole is concerned with subject inventions, and those are the inventions that are conceived or first actually reduced to practice in the performance of work under a funding agreement. And the funding agreement can be a contract, it can be a grant, or it could be a cooperative agreement. If it's first completely conceived of, or it's first built, actually put together in complete working form. And if either of those things happens in the performance of the contract, then that's a subject invention. Next slide. Destiny? There we go. Okay, so why did Bayh-Dole come into place? So in in the late 70s, the US government was funding about half of all US research, with very few of the inventions that the US government was paying for actually making it into the marketplace. Since then, the proportion of US government funding of research has gone down. But it's still true that government does research largely for its own purposes and not necessarily for the purposes of making a commercial invention. You know, we saw that a lot of what we were inventing or funding for inventions just wasn't going anywhere. And at the same time, some of you may be old enough to remember that the late 1970s were an era of what was called stagflation. There was a deep recession coupled with very high inflation. It was a bad economic time, and the government was looking for ways to stimulate economic growth. And you know, a couple of congressmen thought they had a good idea to use the fruits of government R&D to stimulate that growth. At the time, the default policy was for government agencies to just own their own inventions that they were funding. NIH had its own policy of granting title to inventing universities, and DoD had a policy of, you know, not always, but regularly giving title to inventions to our major defense contractors, but not to universities and small businesses, which is a shame because that's where a lot of the most innovative ideas came up, were created. Companies, you know, and universities could ask for waivers from that policy, but that took a long time, you know, often as long as 18 months, which, you know, is not a useful timeline if you're trying to patent and protect an invention. You know, the government just wasn't, you know, highly motivated to process those in any type of expedited fashion. So we ended up with a very large inventory of inventions that just went nowhere and did nothing for anybody. Next slide. So the policy behind BuyDole was to foster economic development by allowing the institutions that created inventions to keep title to those government-funded inventions. At the same time, you know, we wanted to protect the government's investment in that research and development by making sure that the government had a license to that invention, so that we could use it ourselves within the government, and that others that we had you know, used the invention, you know, on our behalf could use the invention as well. So if a company created an invention under BuyDole, we would at least get a license to that invention, and that license would extend not only to the government, but also to our contractors to do work on our behalf. Textually, the statute only extends to small businesses and nonprofits, but by executive order, that was expanded to include all businesses, regardless of size. So pretty much anyone who's working on a funding agreement with the government under a contract, a grant, or a cooperative agreement is going to be enjoying the benefits of BuyDole. Next slide. So here's the basic allocation of rights. The contractor, and I'm using the term contractor generically to refer to contractors, grantees, and parties to a cooperative agreement here. So when I use that term, just understand that I mean all three of those parties. But they have essentially a right of first refusal. they can elect to retain ownership in the US and also in foreign countries to any subject inventions that they make, subject to a license back to the government, allowing the government to use it or have it used on our behalf. If they want to make that election to retain title, there are some things that they have to do. They have to report the invention to the government. They have to, which means just informing the government, hey, we made an invention in the performance of this contract or this grant. They have to disclose the invention, and that means making a technical disclosure of what the invention's about. That could be in the form of a report. Very often it's in the form of the patent application that they filed with the USPTO. That election has to be in writing. So they're going to make a written election. They have to file a patent application. So if they're filing in the US, they have to file in the US. If they're electing to protect the invention in foreign countries, then they have to also file in at least one foreign country. And that's often done through a patent cooperation treaty application. And at the beginning of the text of that patent application, the very first paragraph has to be a description of the government's interest in that invention. So that very first paragraph will have a title, Statement of Government Interest, and it'll say, this invention was funded under contract number, fill in the blank, grant number, fill in the blank. The US government may have rights to this invention. There's a format for it in the Manual of Patent Examination Procedure. Pretty much any patent attorney practicing in this area, working with government contractors at all, should be familiar with that and should know what that language is. The other thing that they have to do is provide a confirmatory instrument to the government for recording at the USPTO. And what that does, that puts the government's license into the chain of title for that patent application. So if the contractor fills that out, signs it, sends it to the government can then send that to the assignment division of the Patent and Trademark Office, and whenever that patent is transferred, sold, whatever may happen to the ownership of it, following that patent wherever it may go will be this confirmatory instrument acknowledging that the government will always have a license to that invention. So that's how the government's rights to that invention are going to be protected. Let's go to the next slide. So how is this implemented? There are clauses that get put into the contracts or grants for small businesses, for nonprofit organizations, and also for all non-DoD contracts. So for contracts that are with any of the civilian agencies, they'll use FAR Clause 52227-11. That's what governs those. For large businesses doing business with DoD, we have a DFARS clause that we use instead. There isn't actually a whole lot of difference between those two other than in timing. The FAR clause gives the small business or nonprofit more time to make the disclosure and make the election than the DFARS clause does. And I think that's just in recognition of the fact that small businesses, don't necessarily have the same administrative resources to manage these things. But the substantive allocation of rights is exactly the same. For grants and cooperation and cooperative agreements, there's a standard clause that's built into the Code of Federal Regulations, and you can see that at 37 CFR section 401.14. I haven't mentioned other transactions, and there's a reason for that. Those are not, strictly speaking, governed by Bayh-Dole. They are outside of the orbit of Bayh-Dole. They just weren't part of it. When Bayh-Dole was enacted, OTAs weren't considered yet. So as a practical matter, what DoD agencies have been doing has been including substantively clauses into their OTAs that provide for the contractor, the OTA contractor, to follow the same requirements that they would if they were subject to Bayh-Dole. Let's move on to the next slide. So here's how there's two different ways typically that our contractors will report inventions to us. The first, even though it's on the right side of the screen, I'll mention iEdison first. This is a portal that NIH has set up. We use it at ONR for our grants and cooperative agreements. It's a very handy, intuitive way of making these invention reports, and the contractors set up their accounts. They submit their information. They attach their disclosures to them. And it's pretty seamless. The problem is that NIH has been paying for this portal out of their own budget. I think they may have finally received a budget line to help support this, but for a long time, NIH was stuck trying to do this on the cheap, and so because of that, they were always asking for help from the other federal agencies to help them pay for maintaining and upgrading iEdison, which we weren't always very generous in doing. For contracts, at least, what we use at ONR, and I think what you'll see at most places throughout DoD, is the DD 882 form. And that's a form that allows a contractor to identify an invention, to provide the names of the inventors, to give us information, to tell us it right there in the form, to make the election right there in the form. Are we electing to retain title in the United States? Yes or no? Are we electing to retain foreign title to the invention? Yes or no? There's a space where they'll be able to provide the information about the patent application if they filed one already. So they'll give us the serial number for that, and they'll sign it and submit it to us. And that's how we learn about most of the inventions that we receive through BuyDole, by means of BuyDole. We have, at ONR at least, we have one person who who monitors all of these for the entire command and keeps track of, what contracts we have going on, R&D contracts, grants, cooperative agreements, when they're due to report, have they submitted their interim or their final report yet, if they have they given us the other things that we require? Have they given us the disclosure? Have they given us the confirmatory instrument that, and have we then taken that and sent it over to the USPTO to record into their chain of title? So those are the two mechanisms that are in use for reporting inventions. Next slide. So there's a couple of special situations that crop up a lot that I want to talk a little bit about. And one is when the government is a joint owner or is entitled to be a joint owner of an invention. As you may have heard me say, BuyDole gives a contractor the right to retain title to an invention. It doesn't give the contractor the right to obtain title. So if for example, a contractor is a support contractor working in a lab, supporting the researchers there, and as part of a research team, the contractor employee makes an invention along with government employees. The government employee is going to be assigning his or her ownership interest to the government, not to the contractor. And the contractor, of course, under BuyDole, has the option of retaining or not retaining their rights to the invention. And it really is, it's still their choice to retain that interest or not. But what they would be retaining is only their joint ownership interest. And if they do, they are still under the obligation to file the patent application. So in those situations, we often see that the calculus for the inventor, for the contractor that employs the inventor, may change. They may find that a little bit less attractive if they're not going to own it outright. There are ways that ownership can be consolidated, that the government lab and the contractor can enter into an agreement to allow the contractor to take the lead on trying to commercialize the invention in exchange for a cut of whatever comes out of it. But those have to be negotiated separately on a one-by-one, case-by-case basis. The other situation that we see come up a lot, again relating to the support contractors that we have at so many of our labs, where the government will enter into a CRADA, a cooperative research and development agreement, with some other organization, some third organization, a company, a university, what have you. And under the terms of the CRADA, the CRADA party has a right to an exclusive license to that invention. Well, if the government support contractor is part of the team that made that invention, that's responsible for that invention, and they have rights under BuyDole, those rights might conflict with the CRADA rights of the CRADA party. So the regulations under BuyDole have been altered to allow for the for the contractor, the support contractor to waive their rights, under BuyDole if they want to participate in the research under the CRADA, so that they go into that effort with their eyes open at least. It's a choice that they can make. The other, and fortunately we don't see this crop up very often, but it was the subject of a Supreme Court case a few years ago, is when the employee of the contractor, they fail to do what they're supposed to do, which is to fill out an assignment form, saying, I, inventor X, hereby assign to you, the contractor, right, all right, title, and ownership of this invention. And they go off and sell it to somebody else. And, the company is then left, the contractor is then left without much recourse, because the employee may have breached their employment contract, but that assignment is legally valid. The way that companies have addressed this in the aftermath of this Supreme Court case is to make part of all of their employment agreements express terms saying that as of my start date, I agree to assign, and I hereby do assign, all the right, title, and interest in any inventions that I make in the course of my employment to you, company, right now. I make that assignment effective. So that's how companies have avoided that pretty horrific outcome for them. Next slide. So those were the things that I wanted to talk about. And if there are any questions, I'd be happy to take those. If not, I would thank you very much for your time.
So thanks to both Barry and John. I think your presentations were chock full of information. So either you were crystal clear on what you guys do, which I think you were, or people are absorbing all the data. So we'll leave some open communications with you to get any questions answered that come in. But in the beginning of your presentation, you had said, hey, if it's intellectual property, you'll be coming to me anyway. So are you the lead IP attorney for the entire Department of the Navy, and then also the Sitter stuff?
I'm not. That would be my boss, John Forrest. But
okay.
What does happen is the IP attorneys at all the various labs and all the various systems commands around the department, they whenever they have a hard problem, they call me and say, hey John, what do you think of this? And if it's really hard, then I kick it over to Barry. But I get at least all the semi-hard questions first.
So for Department of the Navy, are you all responsible for reporting all of the intellectual property and that patents and such?
Yes. So there's an annual report that all of DoD makes to Congress, reporting on how many inventions were made, how many patent applications were filed and issued, and how many licenses to those inventions we issued, and how much money those licenses brought in. And so our office collects all of that data and reports it to DoD, and then they collect all of that and include it in their report to Congress.
So does the Department of Navy, do we get a lot of money off of the trades and programs, and what happens with that money?
So that's a great question. We share a sizable chunk of whatever we bring in with the inventors. We bring in a few $1,000,000 a year, not
Okay.
you know, an amazing amount of money. We're not going to be buying submarines with it, but it does help to fund the tech transfer programs at these different labs. ONR acts as the clearinghouse for those payments, and then we send them out to the labs. And what the labs do is they'll take the first $2,000 off the top, pay each of the inventors, you know, that, and then whatever's left over after that, the inventors split 20% and the lab keeps 80%. There's an annual cap of $150,000 a year, which was recently within DoD as part of a pilot program that was actually raised up to $500,000 a year. So our government, now that's for our government employee inventors. All of that happens. For the BuyDole inventors, the contractor inventors, you know, that's entirely up to the contractor themselves, you know, what to do with any money that they make off of that. If they do, and if they, you know, they choose to share that, you know, those proceeds with their own employees, that's great, and we know that a lot of them do. But that's really up to them.
Okay, great. Thank you. And one last question that I had was, so when I first came on board to OSBP, I had to go to a small business quarterly meeting and I had to learn about OTAs. A lot of information out there on OTAs. I worked with them a long time ago when we had the dual use program, but it's changed since then. But realized that OTAs were at first considered a great vehicle to get to non-traditional partners in working with the government. One of the stumbling blocks was the intellectual property rights. Mm-hmm. So over the past several years, with more people using OTAs, have you seen that kind of go away? Are non-traditional partners more willing to work with the Department of the Navy and small businesses because of that?
I think the great thing and the difficult thing about OTAs is that they're a blank slate. You can do almost whatever you want to with them. So we can allocate IP rights, you know, data rights and patent rights pretty much any way we want to. The problem is, you know, the challenge then becomes, okay, that means that we've got to address, you know, from scratch, you know, in each OTA, what those should look like. So you know, at least on the patent side, we tend to, you know, run back to the BuyDole allocation of rights, you know, by putting those kinds of terms and conditions into the OTA. It's largely because it seems like a fair and reasonable allocation. If you know, if we're giving the you know, the other party a right of first refusal and only asking back, you know, from them a license for us, that's you know, not too many companies could fairly complain about that. I don't know, Barry, did you want to talk about data rights under OTAs at all?
Under OTAs, we've taken the position that SBIR data rights need to be respected under OTAs. That can make things complicated, though, when you have several participants in an OTA, only some of which are SBIR participants. So that makes life interesting. But we're of that position in reading the SBA policy directive, which is interesting because the language in the SBA statute regarding SBIR data rights is almost the same as the language in the BuyDole legislation regarding the types of agreements, but the legislative history is a bit different. And by the way, John, before you started hitting off all the difficult problems to me, my hair was black.
There is one final point I wanted to make is if folks are really interested in BuyDole and what's happening with BuyDole and where BuyDole is going, right now, until April 5th, there's a Department of Commerce is looking to update the regulations governing BuyDole, and in January they published proposed rules, and the comment period on that is open right now. So if that's an area that's of interest to anyone out there, right now would be the time to look at that and to comment if you think that's worthwhile for you.
Great. Well, again, Barry, John, we're going to keep, if we get any other questions in here in the next couple of days, I'll certainly field them out to you and get them answered. But I want to thank you both so very much for participating with us today and providing all this valuable information to our small business audience. I'd like to thank Destiny White, our public affairs officer. She's behind the scenes doing all this great stuff to make everybody look good. If anybody has a topic that you'd like to see presented in a webinar, go ahead and email osbp.pao@navy.mil. We'll certainly get a topic teed up for you. But until next time, everybody stay safe, stay healthy, and have a great day.
Thank you.
Thank you. Bye.
Bye, everyone.